Welcome to Taxpayer Alert. My name is Al Segala. I'm president of the Calaveras County Taxpayer Association, and which is sponsoring this series of programs. And our special guest at this session is Richard Fields of the Pacific Legal Foundation. Richard, welcome.
Thank you.
Tell us a little bit about the foundation and what you do.
Well, Pacific Legal Foundation is a public interest law firm. Essentially, we're a law firm with a couple of twists. Twist number one is everything we do, everything our attorneys do, is done pro bono, for free. We don't charge our clients anything. Twist number two is we are very careful about the kinds of cases that we take. We pick and choose. We take cases that, very broadly speaking, defend property rights and other individual liberties of the American people. We've got 25 attorneys that operate, and we do cases all over the country. I think we've got cases in some 30 states right now, over 150 cases ongoing at any given point in time. And my job at Pacific Legal Foundation is, since we are nonprofit and since we don't charge our clients anything, my job is to make sure that we receive enough in donated income in order to pay the attorneys and keep the foundation solvent. And to that end, I would suggest everybody go to www.pacificlegal.org, which is our website, and find that Donate Now button if you like what I have to say this evening.
Well, we'll be sure to say that several times.
Okay.
But nowadays, there's a new twist on websites. You don't have to say www anymore.
Yeah, I'm old school, I guess.
Well, that's very good. Well, let's start with Sackett versus EPA, Kuntz versus ST.
Yeah, okay, the first case that you mentioned, Sackett versus the EPA, Environmental Protection Agency, is a case that we won in the U.S. Supreme Court in 2012, last year. The case started a number of years prior to that, when a young couple up in Priest Lake, Idaho, who owned a dirt moving company, an excavation company in the construction industry, decided they wanted to buy themselves, or actually build themselves, a new 3-bedroom home. And they found their dream lot location in a subdivision across the street from Priest Lake, Idaho. And it had a view of the lake, and it was a very nice lot, and they were very excited about buying the lot. They paid $23,000 of their hard-earned money for the lot. They put together plans for a modest 3-bedroom home. They got all of the local permits from the permitting agencies from Priest Lake, and were proceeding to move dirt to lay the foundation to build their home, when they were visited by a couple of agents from 6 hours south of them, Boise, Idaho, agents from the EPA, Environmental Protection Agency. And the EPA agents said, "Cease and desist, you're building on a wetlands." And the Sacketts, totally mystified at the request, or actually the order, said, "I'm sorry, what do you mean wetlands? This is a subdivision. There's a house on the left, a house on the right, a road in front of us, a road in back of us. There's no standing water, there are no streams, there's no runoff at all except during a thunderstorm. What do you mean wetlands? This is not a wetlands." And the EPA said, "Sorry, we've decided it's a wetlands." Well, there's obviously been some mistake, the Sackett said. So, we'd like to appeal that wetland delineation thing you've got going here, and just get this behind us. And the EPA said, "Sorry, no appeal process possible. The only thing that you can do," after a lot of asking questions, they found out that the EPA told them the only thing that they could do. They had two choices. One, they could build a fence around their half-an-acre lot, and plant wetland plants that had never ever been there before, and maintain that fence for a 5-year period, allowing the EPA total unfettered access whenever they wanted to come and check it out. And after 5 years, they could apply for a wetlands, an after-the-fact wetlands permit from the Army Corps of Engineers. And they would get their day in court, because the Army Corps of Engineers would almost certainly deny their application, and then they could fight the application in court, or the denial in court. Problem with that scenario was, number one, 5 years. Number two, the wetland permit application would cost over $100,000 in cash to process this on a $23,000 lot. And the second alternative that they were offered was, well, you could just ignore our wetland delineation order and go on your merry way and build your house. Of course, in doing so, we would, whenever we feel like it, no telling when, but whenever we feel like it, we would, we would take an enforcement action. Once there's an enforcement action taken, then you get your day in court. Of course, you're subject to $75,000 per day in penalties. Plus, you're subject to criminal prosecution. You can go to jail. So take your choice. You can wait 5 years, or you can risk jail and $75,000 a day fines. Those are the only two avenues you have to appeal our fiat declaration that this is in fact a wetlands, which of course it's not. So the Sacketts at that point were getting a little bit frustrated, so they sought out the advice of an attorney from Spokane, Washington, across the state border, and the attorney said, I'd love to help you, but there's a problem. Every circuit court, federal circuit court in the country, has ruled with the EPA on this particular issue. Therefore, even though it looks like an open and shut case that you should be able to appeal, you can't. And without spending a whole lot of money going through the appellate process to get the courts to overturn precedent. And I can't take your money. I can't in good faith recommend that you go forward with this. The only thing I can suggest you do, and it's a long shot, is talk to Pacific Legal Foundation down in Sacramento. They like to tilt at these kinds of windmills. They may take your case, and if they do, they'll pursue it. So the Sacketts contacted us. A young attorney by the name of Damian Schiff, who was in his late 20s at the time, said, this is a real interesting case. I think I will take this case. And got board approval, took the case, went to district court in Boise, Idaho, lost the case as expected, because the district courts follow court precedent. So they appealed to the Ninth Circuit Court of Appeal, and of course, we at Pacific Legal are used to losing at the Ninth. We kind of welcome losing at the Ninth because it gives us a chance to appeal to the U.S. Supreme Court, which we did, and we appealed and took that 1 in 100 chance, because only 1 out of 100 cases are accepted by the Supreme Court. They took the case, and then in January of 2012, the case was argued, and by June we got a decision which, interestingly enough, was unanimous. Saying that the Sacketts had the right to appeal, had the right to an appellate process to appeal a wetlands delineation. The important part of this case is that it sets a precedent that is applicable across the country. Every landowner who is facing an inappropriate wetlands delineation now has the right to appeal. Didn't have that before. And so there's 3,000 or 4,000 people every year that get hit with these things, and essentially, prior to Sackett, had nowhere to turn, nothing that they could actually do unless they had very deep pockets. And of course, somebody building a 3-bedroom home on a $23,000 lot can't afford to spend hundreds of thousands of dollars fighting the EPA, fighting the federal government in court. So that's the Sackett case.
What a blessing, especially for the little people that would just give up.
Yeah, I mean, the Sacketts really, or people in that kind of a situation, really have no choice. They can either fold their cards and say, kiss their $23,000 goodbye, and pay try to sell it, which, good luck with that, selling an undevelopable piece of property, or continue to pay property taxes on a piece of property they can do nothing with. That's the sad situation that people were in prior to Sackett, prior to the case.
Now, I understand that the Pacific Legal Foundation will accept donations at pacificlegal.org.
Yeah, I made that point earlier.
Okay.
Yeah, you can repeat that, sure.
Now, the next one is Johns River Management District.
St. Johns River Water Management, it's actually Kuntz versus St. Johns River Water Management District. And this is another U.S. Supreme Court case that we won this year. Coy Kuntz was a developer, and back in the 1990s, he decided to buy, I think it was 14 or 15 acres of land at the intersection of of 2 major highways just outside of Orlando, Florida. And his goal was to take 3 or 4 acres right at the intersection and put in a strip center, a strip shopping mall. He needed to get a permit, a building permit, from the St. Johns River Water Management District. They were the permitting authority for that particular piece of land. So he applied for the permit. The St. Johns River Water Management District said, well, we can give you a permit, but there are conditions. Here are our conditions. First, you have to dedicate 12 acres of this land as wetlands. And 12 acres of the 15 were arguably wetlands, so Coy Koontz agreed to do that. He said, okay, you can have 12 acres if you give me the permit for the remaining 3 or whatever, I mean, using round numbers here. And Coy said, okay, let's do this thing. And the Water District said, or St. John said, one more thing. We want $150,000 or services worth up to $150,000 for you to go in and put culverts and do other water management duties on our land 4 or 5 miles away. And Coy said, wait a minute, you want me to fix up your property in order to get a building permit on my property? No way, I'm not going to do that. He's a stubborn old coot. He grew up in Appalachia. He wasn't about to bend over on that request. And so the St. Johns River Water Management District said, well, okay, no permit then. And so Coy was stuck. So he went to court in Florida. He went to state court and actually won in state court, saying that the Water District had to give him a permit and pay damages. The Water District appealed to the Florida appellate court, and he won it. Coy Koontz won again. But unfortunately, the Water District then appealed to the Florida State Supreme Court, and at the state level, they reversed, and Coy lost. And so here he was, a number of years after he was trying to get his building permit, with a state Supreme Court saying that you have to do what the Water District wants. You have to, fix their culverts. At that point, we stepped in and appealed to the United States Supreme Court. And again, the U.S. Supreme Court took the case. And by this time, Coy had passed away. This thing has been going on since the early 90s. But his son, Coy Koontz Jr., took over and pursued the case. And we represented Coy Koontz Jr. in the estate and went to the U.S. Supreme Court, and we won there with a 5-4 decision, saying that not only does the Water District have to give you the permit and can't put in an extortionate condition on that permit, but it set a really interesting precedent for people who want to use their property. And it builds on a precedent that we at Pacific Legal won about 15 years ago, which was the Nolan case, Nolan versus California Coastal Commission. In that case, Pat Nolan and his wife decided they wanted to remodel a bungalow on the Pacific coast in Ventura County that they'd purchased. Interior remodel job, basically. The California Coastal Commission said, no, you can't do that unless you do a couple of things that we want. Number one, we want an easement taking up, amounting to 1/3 of your beachfront. You have to give us an easement for 1/3 of your property in order for us to give you a permit.
The taking.
Which is, under the Fifth Amendment, a taking, clear and simple. The rule there is that permitting authorities can demand something. In other words, if you're a developer and put in a subdivision, the permitting authority can say, well, you have to build roads to the subdivision because that's something that is, there's going to be an effect on the public, and you need to mitigate that effect. But there's nothing reasonable about taking 1/3 of your land in order to do an interior remodel job. So we won that case, and the case essentially said you can't take somebody's real estate as a condition for a building permit. What governments have been doing ever since then, gradually, is learning, well, we won't take your real estate, we'll just take your money, or your services, or your sweat and blood. And the Koontz case says, no, a taking is a taking is a taking. It doesn't make any difference if the government is taking real estate, or taking services, or taking money. If it's a taking and it's not reasonably relevant to the building that's going on, you can't do it. So another very good precedent that helps out people who want to develop property anywhere in the country.
I have a question of the cases that Pacific Legal Foundation has appealed to the Supreme Court. How many of those get heard?
Well, that's a statistic that I don't have. Now, I do. The statistic that I do have is that of the 8 cases that we've taken to the court, we've won 7 of them, the last 7. We've only lost once at the U.S. Supreme Court on a direct rep case. Now, we do a lot of amicus cases at the U.S. Supreme Court as well. Amicus is a friend of the court where we file a brief on behalf of one party or the other in the court, and we've had a good record of being on the right side in those types of cases as well.
The next case is, oh, by the way, you will accept donations for the Pacific Legal Foundation at the website pacificlegal.org.
Yes, and we're located in Sacramento. If people want to look us up on the internet, we're in Sacramento. Yeah. That's our headquarters. We've also got branch offices in Florida and in Washington State, Bellevue, Washington State. So those are other places where we have attorneys and other support staff based.
Okay, our next case is SB 32.
Well, you're probably familiar with SB 32 here in California.
Yeah, well, we are.
And I would imagine it's probably affecting people in Calaveras County one way or another.
Yeah, yes, it is.
Okay. SB 32, for those of you who are uninitiated, is the legislation passed by the California legislature that gives California Air Resources Board, CARB, the duty to reduce the amount of carbon dioxide pollution going into the air, and to do a certain amount of reduction over a certain time period, et cetera, et cetera. Now, the method that CARB has chosen to meet that mandate is what we're attacking. What CARB did is they said, okay, one way that we can do this is we can set up carbon dioxide credit auctions. In other words, we can sell the right to put carbon dioxide into the air to the highest bidder. And the way they set it up is they said, okay, we're going to create X number of credits. We're going to give away half of the credits, free, gratis, no charge. The half that they're giving away go to people or businesses who could easily move their business out of California if they so choose. The credits that they decided to sell or the people who don't get free credits are the people who have businesses that are pretty much stuck in California. They don't have it.
Extortion.
They don't have a choice in moving. So our lead plaintiff is Morningstar Packing Company. Morningstar is a tomato processor in the Central Valley. They don't have the luxury of moving their tomato processing plants out of California because that's where the tomato fields are. And if you use ketchup or you eat salsa or any kind of processed tomatoes, chances are it came from Morningstar. And one of the boilers at Morningstar, which burns fuel, which emits carbon dioxide. So they've had to spend several, 5 figures, thousands of dollars on carbon credits in order to stay in business. Money that they were not spending prior to that. That's increasing, obviously, the cost of ketchup and salsa and stewed tomatoes because they're not doing this for nothing. They're not, those costs get passed along. So what CARB is doing is they're increasing the cost of processed tomatoes and they're increasing the cost of timber because timber companies are affected because they run diesel equipment. Trucking companies are affected because they do over-the-road trucking. Any number of companies in California are affected. In fact, we've got probably, half a dozen or a dozen plaintiffs in addition to Morningstar on this case. And the legal argument that we're making is a very interesting argument. We're saying that the California Air Resources Board doesn't have the power to levy taxes. And we're saying that an auction scheme that raises $11 billion over a 10-year period walks like a tax, talks like a tax, probably is a tax. And if it's a tax in California, under the California Constitution, taxes have to be passed by a 2/3 vote of the California legislature, both houses. That particular piece of legislation wasn't passed by a 2/3 vote, and nothing was said about a carbon credit auction or a tax of any kind in the legislation that authorized CARB to do what they're doing. So there are 2 kinds of cases that we do. One is constitutional, and this is a good example of a constitutional case, and the other kind of case that we do is where an agency oversteps its bounds and does something that is not authorized under the enabling legislation.
This is
And
both.
So, yeah, this one is both. Yeah, this one is both. CARB is essentially a renegade agency in the sense that they're going out and raising taxes willy-nilly without any congressional or constitutional authorization to do so. I
understand that CARB is based on a theory that carbon dioxide is a pollutant.
It is. Now, I have to say, whatever our personal opinions are, we don't get into the science of whether carbon dioxide is pollution. We don't get into the science of whether or not more carbon dioxide is being produced as a result of global warming or any of that. What we do is we say, if you're going to enact legislation that deals with carbon dioxide emission or any kind of pollution, you have to do it in a legal way. You have to follow the state constitution or the federal constitution, as the case may be.
So what is the status of that case now?
It was filed earlier this month, so it's at the district court level at this point in Sacramento.
Okay, so that means that it would go to the ninth district court?
No, it would. It's filed in state district court, so it will. Whoever loses will undoubtedly appeal. It'll go to the state appellate court, and from there it goes to the California Supreme Court.
Okay.
And theoretically, it could go to the U.S. Supreme Court. So we don't know yet.
One of the things I'm grateful for is the carbon dioxide, because it allows the plants to grow. And if you believe in a green world, you want to support carbon dioxide wherever you can. Yes, and you also want to have the right to exhale, because that makes inhaling a lot easier. Yes. The next item is our Obama case, our Obamacare case. Yeah, I'm sure remember the Obamacare litigation of 2012. Obamacare was passed by Congress, and it was based, or the argument against it that we and a number of other folks made back in 2012 was that Obamacare was unconstitutional because it violates the Interstate Commerce Clause of the Constitution. And the way it violates the Interstate Commerce Clause is it mandates coverage. It mandates people buying health insurance. In other words, it tells people that they must engage in commerce, whether they want to or not. The Interstate Commerce Clause is about regulating commerce among the several states, not about forcing commerce to occur. So that was the argument that we made, saying that all of Obamacare should be invalidated based on that unconstitutional provision. And the court actually, as you remember, agreed with that argument. They said, we cannot justify Obamacare based on the or based on the Interstate Commerce Commission. But John Roberts, for whatever reason, decided to go off the reservation and say, but we're going to say it's okay as a tax. We'll let it pass as a tax. We're taxing people for not buying health insurance. We'll let it go. We'll let it go on that basis. Call it a tax as everything. So he's rewriting the
He essentially rewrote the legislation, yes.
Oh.
Or rewrote it in part. And in any case, Obamacare lives to this day because it was branded a tax rather than a regulatory scheme. That being the case, we took another close look at it. Now, our client is Matt Sissel. He's a retired or former medic in the United States Army. He served in Iraq, veteran. He's also a very fine artist, portraiture artist in pen and ink, and he has his own art studio in Forest City, Iowa. He's a young guy in his early 30s, healthy, wants to buy a kind of health insurance that meets his needs, which would probably, I'm not sure what he wants to buy, but it's probably major medical with, I'll pay for the first $10,000 of health care expenses myself because I don't have any. That's what he wants to buy. Under Obamacare, that's not what he can buy. The only thing he can do is essentially a one or two size fits all scheme mandated by the super medical brains in Congress. And he doesn't want to buy that kind of a health insurance policy. So what we did with his case is we amended the case. We said, okay, if Obamacare is now a tax, we need to take a look at another clause of the Constitution, the origination clause. The origination clause says that all revenue-raising measures must originate in the House of Representatives.
That's true, yeah.
And Obamacare didn't. It started in the Senate. So yeah. Our case is very simple, open and shut. Didn't start in the Senate, totally illegitimate. The entire act must be overturned.
And what is
District Court in Washington, D.C., the district court judge who coincidentally is an Obama appointee, ruled against us at the district court level. We've appealed to the, I think it's the Fifth Circuit Court of Appeals on the East Coast.
Oh boy, what a
And that will
struggle.
eventually get, I'm sure that will eventually get, at least be appealed to the U.S. Supreme Court.
Wow, that's pretty awesome. The website for making donations to the Pacific Legal Foundation is pacificlegal.org.
There you go.
Our next case is the Utah prairie dog endangered species case.
Yeah, I like the name of the client in this particular case. It's
Is
the
it a dog?
No, well, no, it's not. It's the People for the Ethical Treatment of Property Owners.
Oh, very good.
And we do a lot of work on the Endangered Species Act. Now, what does endangered species have to do with property? It's really quite simple. If you have an endangered species, what the U.S. Fish and Wildlife Service does is it says, okay, the habitat of the endangered species, in other words, where that particular animal hangs out, is going to be very highly regulated. We're going to regulate it, meaning that if you own that particular piece of real estate, there's a whole lot of things you can't do with it. And in the case of the prairie dog, essentially, the prairie dog has taken over this particular town. And what the prairie dog is doing is it's digging up its holes in the cemetery, digging up old graves. It's causing problems on football fields where they have their holes, and people are running across the football field and stepping in a prairie dog hole. And the Fish and Wildlife Service is saying that since we've called this an endangered species, you can't do anything about it. You can't move them. You can't trap them. You can't. You're stuck. You're stuck with a town being overrun by prairie dogs making holes all over the place. It's messing up the sewers. It's just a real pest. The problem, of course, from our standpoint, is that it's not an endangered species. It's a subspecies of the prairie dog, which looks slightly different, sort of like I look slightly different than somebody from Sweden or somebody from Africa. That's what it is. It's a subspecies. It interbreeds perfectly fine with any other subspecies of prairie dog anywhere else in the country, and prairie dogs are not endangered in any way, shape, or form. So we're saying this is not correctly identified as a species or a subspecies. It should not be on the endangered species list. Therefore, get it off the list so that it can be managed, and so that people in the small town in Utah can go on with life without having to worry about a prairie dog infestation.
Wouldn't the Endangered Species Act be a violation of the 10th Amendment? 10th Amendment calls for those things that are not specified in the Constitution to go to the people or the states.
That's an interesting question. We made that argument on another endangered species case of ours, which was the Delta smelt. The Delta smelt is a species that is found only in California, only in the Sacramento River Delta. Since it's only found in California, we argued that Fish and Wildlife has no authority to call it a subspecies or a species or any jurisdiction whatsoever to do anything about it. And since unfortunately, on that particular case, the court didn't agree with it. But if it's a species that's found elsewhere, unfortunately, that argument doesn't apply.
We want to thank you for joining us this time, and thank you for joining us at Taxpayer Alert.
Thank you very much for the opportunity. Love the chance to talk a little bit about Pacific Legal Foundation.